Hi everyone, this is Avi Leibovic, and you're watching another one of the amazing webinars that's offered by Benefits for All, where we teach you how to win your Social Security disability benefits without necessarily having to hire an expensive attorney or hearing representative. I'm standing in New Jersey, in Hackensack, beautiful Bergen County, at a historical landmark. That's right, the bridge behind me is called the New Bridge Historical Landing, or the Historical New Bridge Landing, or some variation of that, right? Doesn't that look like a national landmark, like preserved, and they give money for funding? Unbelievable, right? Well, I honest to God, this is a historical landmark. So why is this a historical landmark? Now, I was going to say the story goes, but it's not the story goes, it's fact. The facts are George Washington, that's right. At that time he was General George Washington, eventually become President George Washington. As you remember, at the beginning of the Revolutionary War, it was just starting. They were fighting against the British. And as you can imagine, the British were not all that happy that the Americans wanted to go and have their own country. To them, this was supposed to be a New England, an extension of the England, right? But the Americans came, they said, sorry, but the colonists came and they said, no, we want our new country, it's called America. So the story goes is that George Washington was on this bridge with about 900 soldiers, or somewhere around here there were 900 soldiers. And this is a very important military strategic point. Why? Because of the river. And it was reported to him that 2,500 British troops were coming. 900 against 2,500. Now, on one hand, you have to hold the bridge. On the other hand, if they would have stayed, they would have gotten slaughtered. So what he did actually was he retreated back. That's right, he pulled back until he was able to set up and connect with some other troops and have some additional reinforcement. And by retreating backwards, he was able to reinforce himself and then eventually fight and overcome the British in that battle. And this became a very famous location, a very famous battle, again called the New Bridge battle, where he retreated. And it's a very famous part of the American Revolution. And it is a historical landmark, just up there with Mount Rushmore and so many other the historic places in the United States that have been designated as places that need to be federally funded and preserved for the history of our country. So why is that important and why am I here? Let's get focused on that. And what can we learn about George Washington retreating, right? No one here would expect me to come and talk to you about retreating, about backing up. But the truth is that sometimes, even as an attorney, it's my job to advise some of my clients at times that even though we took a case and even though we move forward on a case, there are some times where you need to withdraw from a case. What does that mean, withdraw? Well, it's very simple. And we're going to take us past the application level, past the request for reconsideration level, and we're putting us up to what? To a couple days before the hearing level or the morning of the hearing level. Now, when we accept the case in our office, we go through a screening, and all the questions are answered to us on the phone by you, the claimants. And we take you, the claimant, on your word, right? If you're telling us you have a back problem, we believe you. If you're telling us you have a heart problem, we believe you. If you're telling us you have a combination of problems, we believe you. And then together with your age and together with, your past relevant work history or when your onset dates were, we move forward on a case. Now, very often, even though we filed the application, it's not like you're coming to us with the medical records and we're reviewing the medical records and then we're saying, oh, we take the case. No. We take the case, we file the paperwork, and then we get the medical records and we accept everything based on what you tell us. Now, unfortunately, very often what happens is that as the medical records start to come in, and as you start to review the medical records to make sure that, in fact, you have a winning case, you say, hold up, wait a minute, right? Hold up, wait a minute. These medical records don't match what you, the claimant, told me on the phone. You told me on the phone that you're disabled and you can't move and things are terrible and you're dying or whatever the problem is, but these records say that your range of motion is normal. These records say that that time that you went to the hospital, you were discharged after 1 day because they couldn't find anything wrong with you. The x-rays don't show problems. The laboratory doesn't show problems. Something is going on here because what you told us when we started the case, right, what you believed to be true about yourself, and it could be that you felt pain, it could be that you felt discomfort, and it could be that in your mind you really truly believed that you couldn't work anymore and you were disabled. So you called us up and we listened to you and we filed the application, but now that the medical records have come in, we see that those medical records really do not support a case, and they certainly don't support a winning case. So what do? We have the hearing coming up, we said today is the day of the hearing, let's say, and your hearing's later today, and it's a very, very difficult judge, right? Very difficult judge. And we said before that when you go into a hearing, for those of you who have been paying attention and buying and purchasing and learning and studying these webinars, I told you that you don't just go into a hearing and say, ouch, ooh, everything hurts me. You're not going to win your case. The way that you win your case is by going into the hearing and understanding that the judge has to go through, we said, 5 steps. There's a 5-step sequential evaluation which the judge has to do in order to go ahead and approve your case. Very quickly, I'm not going to go through a big explanation of all of them. You're going to have to watch the webinar. We said step number 1, are you engaged in SGA, right? $1,130. Step number 2, do you have a severe impairment expected to last 12 or more months and or result in death? Number 3, does your impairment or your combination impairment either meet or equal one of the listings in the Social Security books? Number 4, what do we say? Can you return back to work? And number 5, if you can't return back to work, can you get any other job in the national economy? So when you go into a hearing, when the judge is asking you all these different questions, what do you do during the day, and how much can you carry, and how much can you run, and how long have you had these medical conditions, he or she is asking what seems like random questions or just background questions, but they're not just background questions. We discussed in one of the webinars that these questions, although they seem to be neutral and relaxed, these questions are really, really very, very intricate, and they're asked with a specific intent so that what? So that you could go ahead and give an answer, and then the judge will use that answer and plug it into the 5-step sequential. You may be answering something without even understanding why the judge asked that, and you may be giving a wrong answer. Okay, so let's get back to this. The focus of this, like we said with George Washington, is that he had to retreat. So what happens in a hearing? You really only have potentially 4 different possible outcomes in a hearing. You can have an approval, right? The judge agrees with you. I approve your case. You can have a denial. That's it. I don't believe you. You're out of here. You can have a postponement or rescheduling, right? For whatever different reason. Maybe the medical expert's not ready. Maybe the vocational expert's not ready. Maybe they didn't get all the medical evidence in. The judge says, you know what, we're postponing it. We're sending it somewhere else. Or number 4, you can have something called a withdrawal. The withdrawal is when you come in, the claimant comes into the hearing. You say, Your Honor, I know I did the application and I lost. And then I know I requested the reconsideration and I lost. And I know I requested a request for hearing and I lost. And I know that it's taken 1.5 years, 2 years to get to this point. And really I thought that I was disabled, and really you have no idea how much I need these benefits and how I want to go forward. But I'm aware that my medical records probably are not strong enough to win this case. So because my medical records are not strong enough to win this case, I have a dilemma. I can either move forward with the hearing, and you're going to conduct the hearing and then probably deny me, or I can go ahead and I can try, like I said, postpone it. Give me some more time, Your Honor. I need to get some more medical records, but not every judge is going to do that. Or the third option is I can withdraw. Your Honor, I thought I was disabled. I was hoping I was disabled. The medical evidence is not enough. At this time, I respectfully request that you withdraw my request for a hearing before an administrative law judge, and that you allow me to just walk away from this whole incident as if it never happened. Now, what is the benefit to that? Some of you are thinking to yourself, what is he, an idiot? He might as well just go ahead and have the hearing, right? Let's say you go to a carnival and you know there's some balloons hanging on a target and the guy gives you 5 darts. He says, listen, throw the darts, and if you pop the balloon, you win. You might as well throw all 5 darts. He's giving them to you. Throw it. Go to the hearing. You might as well just throw out the testimony and see what happens. Maybe you'll win your case. It's not that simple. Social Security, it costs them a lot of money to have a hearing. It costs time for the judge, time for the stenographer, the recorder, costs time for the medical expert, the vocational experts, the staff at ODAR to prepare everything. It costs money. And then after the hearing, it costs more money because the judge has to write a decision, which is going to be about 12 to 15 pages. And they have to research it, and they have to scan it and upload it and mail it to you and postage. There's a cost involved to everything. So therefore, Social Security, and this is the most important part of what I'm going to say, Social Security has a rule. If you go to hearing, and if you lose your case at hearing, right, you get an unfavorable decision, what's going to happen is that decision, the decision by the judge, is going to stay on your permanent record with the Social Security Administration, and it will always be tied to your name and your Social Security number. So therefore, if you go ahead and you get an unfavorable decision, Social Security says that the next time that you apply, and that might be in 6 months, That might be in 12 months. It might be whenever you feel you need to apply again. Social Security now puts a new level of requirements on you. It isn't just income and resources and citizenship and residency, and it isn't just showing the medical conditions that you have are going to last 12 or more months, or that you're engaged or not engaged in SGA, but they have something else. Because you took the time of the court and the costs associated with Social Security Administration to go to hearing, and they wrote a decision for you, Social Security says, in this new hearing and in this new application, not only do you have to show that you're disabled, but you have to show that your medical condition is materially worse. It has gotten so much worse than when it was, or how it was last time you applied and you got the unfavorable decision. You see, sometimes it's better to walk away on a withdrawal and then just file a clean application, because when you file a clean application, they're just looking at your application and they're making a judgment just on the application. But if you go ahead and you have a hearing and then you lose and then you have to file a new application, right? It's a court ruling, it's called Chavez, right? A Chavez ruling. The court says not only do you have to show that you're disabled, but you have to show that your condition got worse from before. That's the first thing. So in the same way that George Washington said, hold on, 900 against 2,500 soldiers, I think I better retreat, right? I better strategize and regroup and take on the battle a little bit farther down the road, because if I stay here, I'm going to get slaughtered. Sometimes you may need to regroup. Sometimes you may need to say, you know what? There's no way I'm going to win this case today. I mean, I can't win this case today. I can't meet a listing. I can't meet steps 4 and 5. You understand what that sentence means if you watch the webinar. I need to withdraw my hearing today. I need to regroup like George Washington. I need to withdraw, and then I need to go ahead, and then I need to take the next 4 to 6 months of going to the doctor, of getting the laboratory tests, of going ahead and going to therapy, of going and taking the x-rays. I need to do what I need to do, and I'm going to reapply. Why? Because if I go ahead now and I have this hearing and I lose the hearing, then what? Then I have a major problem on my hand. The major problem is what? Is that the next time I apply, because of this court ruling at Chavez, not only do I have to show that I'm disabled, I have to now show that what? That my medical condition, my disability is worse than what it was the last time I applied. Because they're keeping that decision part of your permanent record, because you went to court and you took the time. Had you withdrawn, then the next time you apply, it's just a regular application. But because you went to court, it's part of your permanent record, and your threshold level for winning and demonstrating your disability is now higher. So with that, my dear friends, we're going to turn around again. We're going to look at this bridge. Now, some of you are saying, is this the original bridge? Actually, if you check it out on Wikipedia, this was rebuilt in the late 1800s. This is not the same bridge from George Washington back in the 1700s, but it is the same location, and it is the exact same landing. They just reinforced it, obviously, with stronger steel or whatever it was. It must have been a wood thing, and the elements must have hit it. And the point is, again, is that just like George Washington understood, and he was a brilliant man, that he had to retreat in order to re-strategize and regroup, and only by retreating and re-strategizing and regrouping was he able to win his case, so too with each of you. You have to sometimes say, my medical records are not strong enough, my case is not strong enough, if I go before the judge, I'm going to get slaughtered, and sometimes it's in your best interest to just be honest about where your medical condition is at, be honest about what medical evidence you have, and be honest about whether or not you think that you can really win your case. Now, that's the first major reason why you should withdraw. There's a second reason why you should consider withdrawing, just like George Washington, and that's a concept called res judicata. I'm not going to talk about res judicata here now, because I want you to focus on withdrawing based on the Chavez ruling, which would require you to have a stronger case the next time you apply, and a material worsening of your medical condition, a material deterioration of your medical condition. I'll just mention what res judicata is, and then we'll have a separate webinar for what res judicata is. Res judicata is that the decision has already been adjudicated. A judge has already looked at the matter, and it's already been resolved and decided on, and the gavel slammed, and the case is done. If you go ahead, I apologize that it's hot. If you go ahead and you file for benefits, and I'm just picking something very simple, and you say from January 1, 2015 to June 1, 2016, I was disabled, whatever your medical condition was, and then you present all your medical evidence from January 1, 2015 to June 2016, and the judge looks at that medical evidence, and the judge says, you know what, I've looked at it, I've studied it, I've thought about it, and you know what, none of this medical evidence comes to the level which shows that you're disabled. So you know what that means? It means The judge has ruled on it, res judicata. And res judicata means that the next time you apply, you cannot use those same medical records from January 1, 2015 through June 2016 and come back and say, you know what? I'm reapplying in June 2016. I have whatever's going to go on my application till June 2017. I'm going to get my hearing in December 2017. But you know what I'm going to do? I'm going to say that I was disabled all the way back with those medical records in 2015. You can't, because the judge has already ruled that that period of time is what? Is already been considered as if you were not disabled. It's res judicata. And for that reason, you have another reason why you should be withdrawing. You should be withdrawing not only because your unfavorable decision will be part of what? Your permanent record, and you're going to have a Chavez threshold for the next hearing, but for the second reason that, you know what? You should say, I don't want to have a res judicata issue the next time I apply. Because the next time I apply, if I submit these medical records, the judge is going to say, no good. But if you have withdrawn and you save those medical records for the next time you apply, then you don't have res judicata. You can say, Your Honor, I'm going to give you some evidence to show how the medical condition worsened and worsened and worsened, and how the situation got more aggravated, more aggravated, more aggravated. It starts back in January 2015. There's no res judicata, and you can see it takes it all the way to our hearing date, which we said was the imaginary second application hearing date of sometime in 2018. I hope that made sense. Think about it, rewatch it, and you'll get it. Think of the bridge. Think of George Washington and his hat. Right? Yankee Doodle Dandy, George Washington, he retreated so he could re-strategize, regroup, reinforce, and then win. Sometimes you need to back away from your hearing. Don't push it. Don't think you're a big shot and you're going to win. Or don't think, you know what? It's going to be okay, because it doesn't always work out like that. I want to tell you, I had a case one time with the sweetest lady that you can imagine. She was really angelic. And part of what made her angelic was she was very, very, very religious. And she spent all of her free time, since she couldn't work, going to church locally. There was only one problem with her case. And I believed her that she didn't feel well, and I believed her that she had a medical condition. There's only one problem with the case. You know what the problem was? Guess. Guess what the problem is. Got it? Jeopardy? Da-na-na-na-na-na-na. Okay, what was the problem? She didn't go to the doctor. She had no medical evidence at all. Nothing. Like nothing. So I said to her, I said, you know, I really think, as your attorney, I have an obligation, a legal duty to tell you that you need to withdraw your hearing. You're not going to win today. So she said to me, oh, I'm going to win. I said, why do you say that? She goes, I have faith. I said, that's terrific. I'm also religious. I also have faith. She goes, that's right. She says to me, Jesus is going to help me win. That's what she said. Jesus is going to help me win. I said, well, I can't challenge you on your faith. Everyone's entitled to faith. I said, but unless there's one of your doctors is named Jesus, and unless his medical records are part of the exhibit file, I'm not sure how you're going to win this case, because you have no medical records. So Jesus better come in here right now and, you know, go ahead and help you win the case, because my recommendation is to you, until Jesus walks through that door, is you should withdraw your case. And what did she say to me? Jesus will help me win. I'm a very strong believer. I have a lot of faith. But do you think that she won the case? She didn't win the case. Because I could say the opposite argument. I could say, maybe Jesus made it that you live in a neighborhood or a community where there's a clinic there. And maybe Jesus made it that medication was available for you in this time in history where you could go get it. And maybe all Jesus wanted was for you to get the x-rays and the medication and the prescription of the doctor so you could win your case. You can't do nothing and say, Jesus will send it to me. God will send it to me. Whoever will send it to me. You have to be honest about who you are, what the strength of your case is, what medical evidence you have, and if you're able to win your case or not win your case. If you're not able to win your case, my recommendation to you, and I'm pretty sure that this would be the recommendation of any solid attorney, any real attorney would tell you, sir, ma'am, you're not going to win this case. You need to back away, you need to re-strategize, you need to go to the doctor for the next couple of months, you need to reinforce, you need to make sure you have all your medical records, withdraw, because otherwise, number one, you're going to have a Chavez issue, or number two, you're going to have a res judicata issue, and if you have both of those, you're dead in the water for this application, and you're dead in the water for the next application. With that, I give you my blessing that you should not be in a situation where you have to withdraw. I give you my encouragement and my advice to get all of the medical records that you need and all the preparation that you need, the documentation, whatever it is, whether it's a technical denial or a medical denial, right? Technical denials, we said in other webinars, are those non-medical denials, the denials that are not based on your medical evidence, but they're denials that are based on what? On a technical issue. Are you a citizen? Do you have residency? Your income, your resources. You may need to provide non-medical proof, birth certificates, marriage license, proof of title to a car, to a house, to a property, bank statements, pay stubs. You may need to provide some of those things. So whether it's a medical issue or a non-medical issue, you don't want to be in a Chavez situation. You don't want to be in a res judicata issue. You want to win your case first time out. Last point, if any of you really understood how much you could get out of watching all of these videos, you would buy the whole collection. You would just tell all your friends about them and you would buy them. If you were a county worker or a social worker or a hospital worker who's watching these videos, you would be running to your supervisor and say, "Supervisor, you got to buy these videos." Because this guy, Avi Leibovic, is teaching us the real deal of how it is to win a case. You don't want to just be a social worker or a county worker who's just filing applications and giving the wrong information to your patients or your clients that are assigned to you. You're a caring person. You want your clients to win. If you're a claimant, you want to win. So you have to listen to me, you have to trust me. The more of these that you purchase, the more of these that you watch, the more success you will have in winning your case and understanding what you need to win your case. If you feel that you've taken on more than you can chew and that maybe this process is not going as smoothly as you thought, or maybe perhaps you're not feeling up to it, again, www and benefits for all. I encourage you to give us a call. I think we'll be able to help you with your case. You certainly will get a free screening and the opportunity to speak to some of the attorneys on our staff, and I think that that would be something that we would be honored to help you with if we can. Until we speak again in the next webinar, and until I have a chance to go ahead and give you more golden nuggets and more strategies and more tips and give you a better understanding, a larger scope, more in-depth appreciation for what you need to do to win your case, my name is Avi Leibovic. Thank you, George Washington, for creating this amazing United States of America. Pledge of Allegiance, right? Liberty and justice for all. Justice for all. It's all about due process. It's all about making sure that the process for applying for your benefits is fair. Every time people would lose, they'd always come to me and they'd say, "It's not fair, it's not fair, it's not fair. I want justice." No justice, no peace. No justice, no peace. Has to be justice for all. It has to be benefits for all. I'm going to help you get your benefits. Benefits for you, benefits for all. Come check it out, Bergen County, New Bridge, George Washington. What a terrific country we live in. What a terrific time in history that we live in, where we can take advantage of all these things, take advantage of the hospitals and the doctors and friends who care about you. There's ample medicine, food, things like that in this country where we can go and get what we need to take care. And I hope you feel great. I hope that you win your case. And until we meet again, Avi Leibovic, all the best and have a great day. Thanks.